their own ethical. In this paper, I will argue that when victims of injustice are dispossessed of their right to choose their own ethical responses to their experience of their victimhood, transitional justice mechanisms, even though created for victims' pain to be acknowledged or affirmed, commit an epistemic injustice against victims. I will begin by giving a working conception of the notion of and examples of transitional justice and its mechanisms. Then I will move on to the TRC as the Truth and Reconciliation Commission as a form of transitional justice mechanism with a specific focus on the legislation that mandated it, which is the Promotion of National Unity and Reconciliation Act of 1995. I'm just going to call it the TRC Act going forward. I find the legislation to be a clearer explainer of the philosophical ideas subtended in the TRC, especially as it pertains to the conceptions of truth and justice propagated by the TRC. Lastly, I will posit the argument that transitional justice mechanisms like South Africa's TRC commit an epistemic injustice against victims when they are forced to conform to predetermined moral responses to their victimhood, as in the case of forgiveness. Okay, so now I'm starting with the notion of transitional justice. We can keep the slide on, thank you. The notion of transitional justice. Transitional justice tries to answer the question, how can the injustice of a former regime be dealt with in bringing about a just regime? I just need to give a little caveat here that I'm assuming that transitional justice exists. There is a lot of literature that questions this assumption, but for the purposes of this paper, I assume that it exists. It is a question with epistemological, political, and moral force. This question of how can the injustice of a former regime be dealt with in bringing about a just regime? Transitional justice is an ill-defined field. There is no consensus on what transitional justice is, the form in which the justice is transitional, nor what makes the transition just. For instance, Kaminsky et al. Refer to it as formal and informal procedures implemented by a group or institution of accepted legitimacy around the time of a transition out of an oppressive or violent social order, while Ruti Title defines it as the conception of justice associated with periods of political change, characterized by legal responses to confront the wrongdoings of repressive predecessor regimes. Another author points to the fact that even in the transitional justice discourse, even the term transition is tenuous because there is no clear consensus as to what the transition entails. Some countries refer to revolutions, others transfers of power, others regime change or restorations or independence or modernization or political development. The common theme is the idea of transitional justice as comprised of 1, juridical processes and procedures during 2, times of political change from oppressive social orders to 3, address the perpetration of large-scale human rights violations committed by previous regimes. These legal processes and procedures are in the main tribunals, trials, truth commissions, and reparations committees, all of which are born from certain philosophies about the nature of justice. Now moving on to mechanisms of transitional justice. Trials and tribunals are underpinned by the idea of justice as retribution. The key idea of retribution in this context is punishment as censure for the violation of human rights with the view to communicate the message that people have equal dignity and that those who violate the dignity of others must be punished. Reparative justice can take the form of what is called redistributive or socioeconomic justice. The focus of reparative justice is on systems that created economic, political, and social marginalization and repairing the inequalities that resulted from these. Truth commissions, on the other hand, are supposedly underpinned by the idea of restorative justice, whereas retributive justice views wrongdoing as a harm against a victim or a law for which the offender should be punished. The aims of restorative justice are to involve, to the extent possible, those who have a stake in a specific offense to collectively identify and address harms, needs, and obligations in order to heal and put things right as possible. The identification of harms includes recognizing and acknowledging the offender's actions as harm. So there's also a moral element to this epistemological project of identifying the wrong. From this perspective, the onus is on the offender to repair the harm they have caused within a process that involves them, the victim, and the community at large. Considering this, justice is not based on punishment inflicted, but to the extent to which harms have been repaired and future harms prevented. The epistemological function of truth commissions, first and foremost, is the uncovering of hidden or unknown information to establish, construct, and expose historical truth and bring it into the public domain for public acknowledgement. Because very often, the past is an argument, so the saying goes. So truth commissions aim to combat the denial of historical injustice. Secondly, on top of uncovering hidden or unknown information, many truth commissions, not all, hold hearings for statements from either the perpetrators and the victims, depending on the truth commission in question. For a truth commission like South Africa's, both parties testify, with the aim being to create a more complete picture of the context of historical injustice. As per the preamble of the TRC Act, this decision was taken for the sake of creating a unitary position of historical truth, a shared understanding of the past that is not the simple imposition of a victor's vision of a united South Africa, or littered with examples of noble visions imposed by a victorious party or by a state. However, for truth commissions such as the South African one, the mandate does not end with fact-finding and public acknowledgement. Those elements are instrumental to its moral mandate of creating the environment for reconciliation to take place. In the next section, I will give a brief historical background to the political context in which the Act was mandated, in order to highlight how the Act was a political instrument in the first place. So the historical background is that during the interim constitution negotiations between 1990 and 1993, there was a call for a law providing for the mechanisms, criteria, and procedures, including tribunals, if any, through which amnesty would be dealt with. It is written in the interim constitution that amnesty for gross human rights violations for political purposes in the case of state actors or actors in the liberation movement. In the interim constitution, amnesty was a necessary step in advancing reconciliation between the people of South Africa and the reconstruction of society. Eventually, the Act was passed in 1995 after considerable input from civil society, including 2 international conferences to explore the transitional justice policies instituted in other countries. It is worth mentioning here that South Africa's TRC is seen as unprecedented, but that is not necessarily the case. In juridical terms, there were some juridical mechanisms put in place that were not called the TRC, such as the Indemnity Committee or I have completely forgotten the other one, a commission of inquiry. Those kinds of juridical instruments have been used before. So when people talk about the TRC as unprecedented, they're not looking at those kind of considerations. But in terms of transitional justice, the TRC was unprecedented in that case because of the idea of reconciliation. The creation of the TRC Act was commissioned in the interim constitution of South Africa, which the constitution itself referred to itself as a historic bridge between the past of a deeply divided society characterized by strife, conflict, untold suffering, and injustice, and a future founded on the recognition of human rights, democracy, and peaceful coexistence for all South Africans. To achieve these goals, according to the Act, there had to be reconciliation between the people of South Africa and the reconstruction of society, as well as amnesty. With amnesty obviously being the primary objective, but it wasn't presented that way. Only in the interim constitution was it clear that the TRC, before it was called the TRC, was actually meant to be an amnesty commission, and the idea of reconciliation came much later. The ethical grounding of establishment of this amnesty was a need for understanding, but not for vengeance. This is now in the preamble. In the postamble of the interim constitution, there was a need for understanding, but not for vengeance, a need for reparation, but not for retaliation, a need for ubuntu, but not for victimization. It must be emphasized, as I've said already, however, that the TRC Act was first and foremost a product of the requirements to facilitate amnesty. It can be surmised that, in essence, the TRC Act was created to solve a political problem: what to do with those who committed human rights violations in apartheid in service of a political objective. So the objectives of the TRC were to provide for the investigation and the establishment of as complete a picture as possible, I'm quoting from the preamble now, of the nature, causes, and extent of gross human rights violations committed from the 1st of March 1960 until the end of March 1994. It was to facilitate the granting of amnesty to persons who make full disclosure of the relevant facts relating to acts associated with a political objective committed during the conflicts of the past during the said period. Another objective was to afford victims an opportunity to relate the violations they suffered. And it was for the taking of measures aimed at the granting of reparations to and the rehabilitation and the restoration of the human rights of victims. Then there had to be a reporting to the nation about such violations and victims. In terms of the Act as a product and vehicle of transitional justice discourse, we can see a couple of elements. Firstly, there were investigations and truth-telling. As a mechanism of transitional justice discourse, the main epistemological aim of the TRC was to establish historical events via investigations and truth-telling, that is, witness statements. Witnesses were to be co-creators of the history to be transcended in order to build a new nation where these acts would not be the norm. The main actors referred to in the Act are the perpetrators of gross human rights violations, who had to give full disclosure of their actions, and their primary and secondary victims, whose role it was to give personal accounts of their experiences of harm. These gross human rights violations were referred to by the acronym CATS, which were killings, abductions, torture, and severe ill treatment. The idea of truth in the Act. In the report, the following elucidations on what came to be referred to as truth during and after the process, the TRC process, are made. The report recognizes and explains different kinds of truth. There's forensic / factual truth, personal or narrative truth, and social or dialogue truth, and healing or restorative truth. The Commission aimed to give victims the chance to tell their experiences of pain during the apartheid regime, a narrative truth that would create a national memory. Social or dialogue truth is described as the truth of experience that is established through interaction, discussion, and debate. Lastly, healing and restorative truth is, according to the report, the kind of truth that places facts and what they mean within the context of human relationships and contributes to the reparation of the damage inflicted in the past and to the prevention of the recurrence of serious abuses in the future. This truth requires acknowledgement of the pain of victims by being placed in the public record, acknowledgement being an affirmation that a person's pain is real and worthy of attention. Thus, the idea was that truth must be told and be acknowledged, and truth would come to be known via an inquiry into history. The truth that would be given a platform for consideration would be that was that which would, it was hoped, lead to the creation of national unity. Now, in the section of the idea of injustice in the Act, one of the major issues in the field of transitional justice that the TRC Act addresses is moral equivalence between the acts of political violence by agents of the state and those by political activists in fighting the state. For this matter, the sentiments of the TRC followed the logic of the international norms of just war theory and international human rights principles. Just war theory is a school of thinking that investigates what a just cause is, or what a moral right for starting or engaging in war entails, and what just conduct is during a war. The reason for the resort to violence by anti-apartheid political activists was considered just by the Commission, but the violent conduct itself was not considered just. Violence was considered a violation of human rights defined by the United Nations as rights inherent to all human beings, regardless of race, sex, nationality, ethnicity, language, religion, or any other status. Human rights include the right to life and liberty, freedom from slavery and torture, freedom of opinion and expression, the right to work, and education. The second part of the name of the TRC refers to reconciliation. The kind of reconciliation envisaged by the decision makers behind the whole TRC process sometimes regarded reconciliation as both a goal and a process, which relied on understanding, reparation, and ubuntu. The censured unethical responses which were in opposition to reconciliation or considered to be in opposition were vengeance, retaliation, and victimization. Moving on to the ethical critique of the TRC Act. Although there are numerous ethical critiques of the TRC, such as substituting justice for peace, limiting the historical time period to be addressed, the stingy definition of perpetrator and victim, restorative versus redistributive justice, it is the requirement of forgiveness that I want to focus on for my argument that when victims of injustice are dispossessed of their right to respond on their own terms, they suffer an epistemic injustice, even in mechanisms that are created for their pain to be acknowledged and affirmed. There are two arguments for forgiveness made by proponents of truth and reconciliation commissions. The argument from catharsis and the argument from the restoration of relationship. With the argument from catharsis, the problem is seen as the trauma experienced by victims. This trauma may manifest as anger, psychological pain, etc. The aim of forgiveness is to allow the victims to heal from these emotions. Restorative justice can honor the need for a victim's healing, a catharsis, if they're receptive to the possibility of repairing the relationship the offender has damaged. Alex Borain, one of the architects of the Act, argues that the logic of truth commissions is that the victims' testimonies were not for historical accuracy because they could not always be verified, but had the psychological function of a catharsis, the purpose of which was to foster healing. Truth-telling embodied the recognition of victims' dignity by acknowledging their unjust experience of pain. But the healing that was envisaged was not just for the victims, but for the country as a whole. This exercise of forgiving, it was envisioned, would help to get victims on the road to forgiveness, the end of which was reconciliation. So this first argument for forgiveness from catharsis is closely related to the second, that from restoration of relationship. According to the explanatory memorandum of the Act was based on the principle that reconciliation depends on forgiveness, and that forgiveness can only take place if gross human rights violations are fully disclosed. What is therefore envisaged in reconciliation is reconciliation through a process of truth-telling and national healing. Healing brought about by forgiveness on the part of victims. When victims receive perpetrators with forgiveness, it says in the explanatory memorandum, forgiveness will follow confession and healing will happen and so contribute to national unity and reconciliation. This forgiveness may also free the perpetrator from their self-imposed prison of guilt. In his book, No Future Without Forgiveness, published after the work of the commission, Desmond Tutu, the chairperson of the commission, describes forgiveness as relinquishing one's rights to enact retribution on a perpetrator. And it is a relinquishment that liberates the victim from the negative psychological burden of seeking retribution. For Jean Hampton, forgiveness means that the victim no longer relates to the offender just in terms of their crime, but that their relationship is renewed so that there is a possibility of relating on other friendlier terms. This is the notion of forgiveness that the TRC supported. According to Jacques Derrida, forgiveness is often confused for excuse, regret, amnesty, and prescription, whereas these synonyms connote the victim not protesting the wrongness of the offense. Forgiveness actually entails the victim acknowledging the wrongness of the offense against themselves in particular, according to Derrida. But he argues that it is always the same concern in terms of transitional justice mechanisms like the truth commissions, to see to it that the nation survives its discords, that the traumatisms give way to the work of mourning, and that the nation state not be overcome by paralysis. But even where it could be justified, this ecological imperative of social and political health has nothing to do with forgiveness. If forgiveness is personal and person to person, this may again be behind the conceptual failure of the expectation of the individualized nature of forgiveness to be universalized to the rest of the nation. If forgiveness is personal, then it cannot and should not be mediated. Otherwise, it ceases being forgiveness and becomes relinquishing the right of the offended party to blame the offender. Victims have the right to assert their dignity by blaming those who violated. Taking the right to withhold forgiveness is an affront to the agency and self-respect of the victim as someone who affirms that a wrong has been committed against them. Once it is mediated by the state, it becomes amnesty or reconciliation or reparation. And then it is no longer forgiveness because the agency of the victim is taken away and replaced with obligation for the victim to overcome their claim to justice. This requirement becomes for the victims to have a conception of history whereby the past and the present are chronological and their coexistence is either incompatible or undesirable or both. In this sense, in prescribing the truth-telling by victims, the TRC obfuscates the way that it is actually prescribing a silencing of the pain of victims. Thus, if a state imposes the expectation of forgiveness on victims, this gives forgiveness an element of temporality that renders injustice as something complete and not ongoing, since we cannot forgive what is still ongoing, but only that which is final. Derrida argues that the imprescriptible, that for which a proportionate punishment is an impossibility, such as a crime against humanity, transcends time. But if forgiveness is used in the juridical realm, it is used at the service of determined finalities. But just as the imprescriptible goes beyond history and the finite time of the law, it will always be subject to judgment. And it is fair to consider that by bringing forgiveness into the juridical realm, perhaps the TRC treated forgiveness as an event and not a process, thus perhaps unwittingly emphasizing a separation between past and present through forgiveness. As Berber Bevenage explains, when it comes to historical injustice, history writing is influenced by and perpetuates a certain idea about the relationship between time and justice. Bevenage refers to a politics of time, a politics which takes the temporal structures of social practices as the specific objects of its transformative or preservative intent. By this, he means that this conception of time confronts epochs, that is, periods in history, which have a beginning and an end, as opposed to social structures that have continuity despite the passage of time. The TRC's turn to history, he argues, forms part of a broader politics of time in which the new South Africa tries to expel the haunting past by actively defining what belongs to its juridical, political, social, and cultural present and what does not. And in this sense, the pain of victims does not belong to the present, and it's something to be overcome. In seeking to compartmentalize the past, the present, and the future, the TRC Act commits an erasure of the moral claims of victims of historical injustice, by presenting historical injustice as simply irreversible and irredeemable. In other words, as simply a tragedy that must be accepted and overcome. That is, a trauma from which it is imperative to heal and which they must leave behind through the exercise of forgiveness. In this manner, the TRC Act subversively makes victims' pain irrelevant to the present and inconvenient to the present. Where forgiveness, in conclusion, where forgiveness plays such a huge juridical, epistemological, and ethical role in the project of the transcendence of the historical injustice in the national consciousness, there is the injunction to forget about the past in the sense of letting go of the demand for justice. This appeal to amnesia and forced emotional positivity or neutrality commits an epistemic justice on victims, even in a mechanism that is supposedly created for their pain to be acknowledged. It does so by prescribing a predetermined moral response to their own victimhood. In South Africa's TRC, this moral response is forgiveness. Prescribing forgiveness is forcing victims to commit to a concept of historical injustice and time that muffles and erases their experience of pain, whereby their agency as moral agents is dismissed. Thank you. Shoo, like I actually Googled how many words for a 25-minute presentation. So I was almost nervous